The High Court of Australia recently handed down a decision in relation to freezing orders arising from an anticipated judgment of a foreign court. To discuss this case, we're joined by Herbert Smith Freehill's partner, Grant Marjoribanks. Grant, can you talk us through the facts of the case and what the court decided?
Sure. Well, this is a very significant decision. It's been recognised now for about 40 years that the courts can freeze a defendant's assets in aid of litigation in the own courts. That's known as a Marjoribanks order after one of the earlier cases. But what this case was about was whether an Australian court can freeze the assets of a defendant in proceedings that are taking place overseas. In this case, we acted for the Singaporean subsidiary of an Australian publicly listed company. Our client was in a joint venture in Indonesia with an Indonesian publicly listed company. The joint venture collapsed. Our client brought proceedings in Singapore seeking several $100 million by way of damages. But the practical issue that we and our client faced is that Singapore judgments are not enforceable in Indonesia, and so we face the very real risk that our client may go through and obtain a really substantial judgment in Singapore but not be able to enforce it at all. So that would just be a waste of time and money. So thinking about options for our client, we searched the Indonesian company's assets worldwide, and we found out that the Indonesian company actually had assets in Australia in the form of shares in a publicly listed company with its head office in Perth. And so we applied to the Supreme Court of Western Australia to get a freezing order over those shares, which we obtained on the basis there was a risk that otherwise any Singaporean judgment would go unfulfilled. Now, the Indonesian defendant there then actually challenged the power of the Supreme Court of Western Australia to make those orders, and essentially said that the Supreme Court of Western Australia couldn't act in a way to effectively protect the Singaporean court's process. It could only act to protect its own processes. And that issue went all the way to the High Court of Australia, and that was what the recent decision was. And a very good outcome for our client. The High Court said no, Supreme Court of Western Australia, and in fact the Supreme Court of any state in Australia and the Federal Court of Australia can make freezing orders over assets held in Australia by a foreign company in aid of proceedings overseas. And that's because Australia allows overseas judgments from certain countries to be enforced in Australia. And because there's the potential for our client to get a judgment in Singapore, which we'd then seek to enforce in Australia, we're also able to get an order from the court to freeze those assets prior to getting judgment. And so the High Court said, well, what's really at stake here is the Australian court is actually supporting its own process. That's the process of enforcing judgment. And they also recognised too that this is a really important issue for international commerce, with Australian companies obviously increasingly doing more and more business overseas. And this was an area where really the law had to keep up with the commercial reality and support that.
What impact do you expect this judgment will have?
It was a very sort of keenly awaited judgment, and it's one that already has been recognised as having really substantial ramifications, for both legally and commercially. Again, with increasingly Australian companies going offshore to invest and do business in foreign jurisdictions, often with foreign counterparties. The High Court decision is a sort of very important weapon in the armoury of Australian companies doing business abroad. Now, it cuts both ways because for Australian companies who are doing business in overseas jurisdictions, they face the risk that if something goes wrong, the counterparty then could seek to freeze their assets in Australia. So it does cut both ways, but it does allow Australian companies the opportunity to take steps to protect their interests in the event of a dispute, and if you like, take steps on their home ground. Possibly the other even broader implication of the decision is it's not actually confined in its potential application to Australian companies. So you could have a situation where you have two overseas companies involved in transactions completely offshore. One of those companies has assets in Australia where the other side seeks a freezing order here. In that case, the only connection that the matter would have with Australia is the fact that one of the parties has got assets in Australia, but you can see overseas companies seeking to take advantage of this sort of very important development in the law in Australia, which in a sense puts Australia ahead of the rest of the world in terms of protection of legal rights.
Thank you for your time today.
You're welcome.